Today, we are jumping straight into a really significant constitutional fight. There's a formal appeal right now, sitting before the Supreme Court, and it's aiming to restrict birthright citizenship. I mean, this challenges a legal idea that's been part of American identity for, what, over 150 years?
It really has. It's fundamental.
So our goal here is to give you the essential guide, sort of a legal shortcut to understanding this whole complex situation. We're going to unpack the sources, focusing on three main things. First, the actual words of the 14th Amendment. Second, the specific legal argument the administration is using to challenge it. And third, the really strong pushback it's gotten from lower courts.
And we should probably start with the core conflict, right? It sounds technical, but it's crucial. The administration's position is that children born in the U.S., if their parents are here unlawfully or just on temporary visas, they shouldn't automatically get citizenship. But, you know, to even make that argument, they have to find a way around, or maybe through, the way we've understood a specific 5-word phrase in the Constitution for a very long time.
Okay, so let's get right into that specific language. This isn't some minor regulation we're talking about. It's the 14th Amendment, ratified right after the Civil War. So for everyone listening, what's the exact constitutional text that this whole debate really hangs on?
It all comes down to the Citizenship Clause. It's pretty clear, actually. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's the key part.
And subject to the jurisdiction thereof. Okay.
And you mentioned its original purpose was clear. Guarantees citizenship to formerly enslaved people, overturn that awful Dred Scott decision. But the legal fight today isn't really about the born in the United States part. No, it's almost entirely focused on what that phrase, subject to the jurisdiction thereof, actually means in practice.
Right. So the history, the original intent regarding slavery, that's agreed upon.
Generally, yes.
The fight is really in the fine print, those 5 words. So for decades, how has the legal system interpreted subject to the jurisdiction thereof? What's been the standard understanding?
Historically, and we're talking well over a century now, the courts have read that clause very broadly. The established precedent basically says, look, if you are physically present in the U.S. and you're not one of the very few exceptions.
Like diplomats.
Exactly. Children of foreign diplomats who obviously owe allegiance elsewhere, or maybe children of an occupying military force. Those are the classic narrow exceptions. Outside of that, if you're born here, you are subject to the jurisdiction, you're subject to U.S. laws, you can be tried in U.S. courts.
So physical presence equals jurisdiction, basically.
Pretty much. And therefore, birth on U.S. soil equals citizenship. That's been the standard interpretation. And the big case, the one every law student learns, is United States v. Wong Kim Ark. That was way back in 1898. That case involved a child born in San Francisco to Chinese parents who were legal permanent residents but couldn't become citizens themselves at the time due to discriminatory laws.
Right.
And the Supreme Court ruled squarely that Wong Kim Ark was a citizen under the 14th Amendment. It really solidified that broad interpretation birth here means citizenship, regardless of the parent's status in many ways.
So that 1898 ruling is the bedrock, the cornerstone that the administration is now trying to dismantle.
That's a good way to put it. Chip away at or dismantle, yeah.
Which brings us to the current administration's actions. Right. You have this massive legal precedent from 1898 and now an executive order aiming to essentially ignore it. When did they formally kick this off?
Well, this policy was launched right at the start of the administration's second term. An executive order was signed specifically aiming to overturn this longstanding precedent.
Day one kind of move.
Felt like it. And that order, it set things in motion. It forced the Justice Department to figure out how to argue this really novel legal position through the court system.
Which eventually led to the appeal we see now at the Supreme Court.
Exactly. It's the culmination of that effort.
Okay, we really need to pick apart their specific argument. It's not just, we prefer this policy. They have a detailed legal theory. Who's making this case for the government, and what's the specific twist they're putting on that subject to the jurisdiction phrase?
The main lawyer arguing this for the administration is the Solicitor General, D. John Sauer.
And the Solicitor General, just to remind listeners, is the government's top lawyer for Supreme Court cases. Right?
That's right. A very influential legal position. And Sauer's legal theory is, it's intricate. He argues that the original historical understanding of subject to the jurisdiction meant something different. He claims it meant being subject to the U.S. government in the sense of having full and complete political allegiance.
political allegiance, not
There's
just physical presence.
Correct. The argument goes that children of undocumented immigrants or even temporary visitors don't meet this standard because their parents ultimately owe loyalty or allegiance to another country.
So the administration is essentially saying the courts, including the Supreme Court in Wong Kim Ark, got it wrong for 125 years.
That's the implication, yeah.
That they misread jurisdiction as just being here when it should have meant something like complete loyalty. That's a huge reinterpretation.
It is a fundamental shift, and Sauer's brief, the legal document filed with the court, explicitly states that the lower courts have, and this is a quote, improperly extended the privilege of American citizenship to people who, under this stricter allegiance test, shouldn't qualify.
And the sources show they connect this legal argument directly to policy goals, don't they? It's not just abstract legal theory.
Oh, absolutely not. Sauer links restricting birthright citizenship directly to national interest. He argues the current interpretation, the status quo, actually undermines our border security.
So they're framing this reinterpretation of the 14th Amendment as necessary for controlling immigration and securing the border.
Precisely. It gives the argument a practical national security dimension, not just a constitutional one. It's framed as being in the nation's best interest to adopt this stricter view.
Okay, that's the administration's case. But now, how did the courts, the ones supposedly misreading the Constitution for over a century, actually react when this executive order landed?
The reaction from the lower federal courts was, well, it was incredibly strong and consistent. They didn't just disagree, they actively blocked the policy from taking effect nationwide.
Nationwide injunctions, yeah.
Yes, multiple courts issued orders stopping the policy everywhere, and the reasoning was consistent. Every lower court that looked at it concluded the policy was unconstitutional, or at least very likely to be found unconstitutional, mainly because of the huge weight of precedent going back to Wong Kim Ark.
And it wasn't just courts in one part of the country, right? Our sources mentioned different circuits.
That's a key point. The policy was challenged and struck down in different places. The Ninth U.S. Circuit Court of Appeals out in San Francisco blocked it. But so did a federal district court way over in New Hampshire.
So you have courts in different regions with potentially different judicial outlooks, all reaching the same conclusion.
Right. That kind of consensus across different jurisdictions really signals how deeply embedded the traditional interpretation of the 14th Amendment is within the judiciary. They essentially saw the executive order as flying directly in the face of settled law.
Now let's look at the other side, the opposition. Civil liberties groups like the ACLU aren't just saying the precedent is old. What's their core constitutional argument against the administration's interpretation?
Their argument goes deeper. The ACLU and others contend that the administration's approach tries to create effectively two different classes of children born on U.S. soil.
Based on their parents' status.
Exactly, which they argue is completely contrary to the entire purpose and text of the 14th Amendment, which aimed for universality. They see this redefinition of jurisdiction as basically an attempt to get around the plain meaning of the Constitution to achieve a specific policy outcome.
An end run, basically.
That's the sentiment, yes. And Cody Wolfsey, an ACLU attorney, quoted in the materials we looked at, put it very bluntly. He said, "This executive order is illegal. Full stop."
Full stop.
And no amount of maneuvering from the administration is going to change that. They're signaling very clearly that they view this not just as wrong, but as fundamentally unconstitutional.
Which leads us right up to today. The Justice Department has formally appealed these lower court losses to the Supreme Court. The stakes are now incredibly high.
Absolutely. And we have a likely timeline for you listening to follow. The first step is the court deciding whether to even hear the case. That's called granting certiorari or granting cert. That decision is expected sometime in the next few months.
Okay. And if they do decide to take the case?
If they grant review, then arguments would probably be scheduled for late winter or perhaps early spring of next year.
And a final ruling?
A final ruling would likely come by the end of the court's term, so potentially early summer.
Now, there's an important distinction here regarding the Supreme Court's previous actions, isn't there? Listeners might remember the court dealing with those nationwide injunctions you mentioned earlier.
Yes, that's a crucial point of nuance.
How is this case different from those earlier disputes about nationwide injunctions?
Okay, so the justices have expressed skepticism about lower courts issuing those broad nationwide orders that block a government policy everywhere. They've actually limited their use in some recent cases. They seem wary of that specific legal tool.
Right.
However, And this is the key difference, they have not yet ruled on the fundamental constitutional question itself. Meaning they haven't decided whether the administration's substantive argument that restrictive reading of subject to the jurisdiction thereof, based on allegiance, actually holds water under the Constitution.
So they've commented on the remedy, the injunction, but not the underlying right, birthright citizenship interpretation.
Exactly. If they take this case now, the focus won't just be on procedural tools like injunctions. The justices will be grappling directly with the core meaning of the citizenship clause and, by extension, what it means to be an American citizen at birth.
That really underscores the significance. This isn't a procedural sideshow. It's potentially a landmark decision on citizenship itself.
Absolutely. It highlights how new and important this specific challenge is. Even with all the lower courts disagreeing with the administration, the Supreme Court gets the final say on the Constitution's meaning.
So let's try to synthesize this. What we have is a major clash between two powerful ideas, forcing a kind of constitutional showdown. On one side, you've got this administration policy view. It's focused on tightening border security, redefining citizenship based on this idea of parental allegiance.
Backed by a novel or perhaps reclaimed historical interpretation of those 5 words in the 14th Amendment.
Right. And on the other side,
You have the amendment itself, born out of the Civil War, designed to guarantee citizenship broadly. And that guarantee is backed by, as we've discussed, over a century of judicial precedent, cemented by that key Wong Kim Ark decision from 1898.
which says birth on U.S. soil, with very few exceptions, is what matters.
Correct. It's really a conflict between legal stability and a push for significant change driven by policy goals, playing out now at the nation's highest court.
So connecting this to the bigger picture, what's the final thought for our listeners to chew on? What are the broader stakes here?
Well, think about this. If the Supreme Court does take the case, and if they ultimately agree with the administration's argument, they wouldn't just be modifying things slightly. They would essentially be overturning Wong Kim Ark.
Reversing 125 years of precedent.
Yes. And you have to ask, what would the ripple effects be? Obviously, it impacts the children of undocumented immigrants and potentially others, but think structurally. What would overturning such a long-standing interpretation of the 14th Amendment mean for the stability of that amendment itself? If the meaning of citizenship, grounded in that text for so long, can be fundamentally altered based on a rereading of jurisdiction.
What other rights or guarantees rooted in the 14th Amendment might suddenly seem less settled, less secure?
Exactly. Could other established interpretations become vulnerable to similar reinterpretations down the road? It raises fundamental questions about constitutional interpretation and stability.
So definitely something for everyone to watch closely.
Yeah.
Keep an eye out for the court's decision on whether to even hear the appeal in the coming months.
And if they do, the arguments next year and that potential ruling by early summer will be incredibly significant for the future understanding of American citizenship.